Hello neighbor, I'm Robert Burns and welcome to segment 7 of the OFI victims litigation against, the Stanford victims litigation against the OFI. And if you will recall, yesterday we talked about 2 jurors having tested positive for COVID, but luckily that is just going to be a small bump in the road because I'm happy to report that there were 14 jurors who showed up this morning. Now, prior to the convening of them coming in, the attorneys had a discussion with Judge Johnson. Mr. Price made it known that he was not happy with this development. In his words, he said, "We lost one of our jurors through this and they gained one of theirs." So he indicated that he had filed a motion for continuance. I assume that his preference would have been to let those 2 jurors isolate for 4 days or whatever the case, and then resume after that. He said that while I'm not happy about this, I guess I'm just going to have to live with it. And the reason that this would be an important development for Mr. Price and the victims is you have to remember the OFI only has to get 4 out of the 12 active jurors to say that there is no liability to prevail. Mr. Price, on the other hand, has to get 9 out of 12 to indicate liability on the part of the OFI in order for him to prevail. So if his statement is correct that we lost one of our jurors and they picked up one of theirs, you can see where that may be a problem. All that has to do with the jury selection process. Obviously, each side tries to pick a jury that's most favorable to them. You have a certain amount of automatic strikes that you can just let somebody go, period, during voir dire. But at any rate, Judge Johnson did go ahead and formally deny Mr. Price's motion to continue. So with that, the first witness was called. That was Mr. Lynn Revere. Now, he was with the OFI from 1989 until 2019, so 30 years. And it indicates that it looks like he was the Deputy Chief Investigator for Securities from I think it was a larger period than this, but he was definitely he got hammered down that he was for the period of 2005 to 2009, which would have been the relevant period during the Stanford situation. He talked about the fact that they would regulate broker-dealers, or explain that those are ones that buy and sell on behalf of the clients. He made this distinguishment between state-registered securities and federal-registered securities. And he indicated that there may only be 15 to 20 entities that are just strictly state securities in Louisiana, whereas the number would be more like 1,500 to 2,000. That would be national companies, and he indicates for them, we just get a mere notice that, hey, we're going to be selling securities in your state. And he said that was certainly the case for Stanford, the Stanford group. And he said they were domiciled in Texas, and Baton Rouge was just a branch. And so he stressed heavily that it would be Texas state regulators that would be their primary regulator, and that he had no reason to doubt a Texas examination report in that regard. Mr. Price kept wanting to emphasize that, well, surely you interacted with the folks in your office who would have been responsible for doing the Stanford Trust examination. And he basically said, no, there would be no reason for me to do that. It was not part of my role in being a securities analyst. Continuing from direct, as I jumped to Mr. Price and the cross, Miss Eddie did a really good job of posing a whole series of questions that would, indicate that the OFI didn't have any reason to take action. That basically there were no alarm bells that would have been such that, hey, we know for a fact fraud is going on here, or even to be suspicious of fraud going on here. And he said the elevation of the CDs would not in and of itself give rise to a suspicion of fraud. And when cross-examination took place, because he had said on direct that he was unaware of any kind of investigation that would have been taking place by a federal agency during the entire tenure that he would have been analyzing any securities, which again he stressed it was not his role to be involved with the folks that would examine Stanford Trust. But upon cross, which was going to be Mr. Price conducting cross, he asked to approach the witness and handed Mr. Revere a subpoena that had been served to the OFI in January of 1999, and it was from the U.S. Treasury. Mr. Revere did say from the stand it looks like it's the Customs Services, but whatever the case, apparently it was from the U.S. Treasury. So Mr. Price wanted to say, so it wasn't accurate what you testified to earlier, that there had been no federal investigation. I guess we're never going to know why the Treasury made that subpoena. The subpoena was for all records of Stanford Financial. Surely they had a reason for doing that, but it also begs the question of, okay, if they turned over these records, you know, I know what Mr. Price is trying to do. He's trying to repeatedly show that there should have been some tip-offs. But if it was a true investigation, it would behoove the question of, well, what came of it? Apparently nothing. But anyway, on that document, it did state that Mr. Revere was listed as one of the ones responsible for the production of documents. Now, Mr. Revere indicated he'd never seen this. He emphasized that, to my knowledge, every statement I made was correct. Let's see. And there again, he stressed his role was to serve as a securities analyst. I may have missed a little bit of Mr. Revere's testimony, but that was largely it. So I'm going to go ahead and move on to what would have to be the star witness of the day, and that would be Miss Carol Van Tassel, with a T, because as I was hearing her name pronounced yesterday, I said, is it a T, is it an R, is it a P? But at any rate, when we're going to give you a link to Miss Van Tassel's webpage of her specialty. She is basically a forensic accountant, and as I explained yesterday, so I'm not going to go into it today, Mr. Price indicated she was the one that basically unraveled the entirety of the Ponzi scheme and had to analyze some 130 companies all involved in this. She had previously, or has previously, served at PricewaterhouseCoopers, which is a big six accounting firm. Believe it or not, way back in 1987, I had a brief tenure with, it was at that time it was Coopers and Lybrand, but I quickly, realized that banking was my true passion, and when I got an opportunity to return to, I was in the New Orleans office of Coopers and Lybrand. When I got an opportunity to return to banking in Baton Rouge, I jumped all over it. But at any rate, she was asked before, and remember, this is a videotape, okay? She's not here live. She had contested the jurisdiction of the court, and basically, as I understand it from some material I said a long time ago, if you're out of state, there's not much a court in Louisiana can do to compel you to, by way of subpoena, to show up and testify. And that may have been the basis of her contesting the jurisdiction. I don't know, but at any rate, she made it clear she wasn't going to be there in person. And most of the intrigue of all of this was actually prior to the jury coming in, because Mr. Price and Mr. Blunt went at it, you know, about her being admitted in as an expert. And Judge Johnson ruled based on the fact that she had testified in numerous other cases as an expert witness, he was going to permit her to testify as an expert. So with the jury back in and brief foundation laid, Mr. Blunt paused the videotape and said, "Your Honor, at this time I would like to have her declared an expert witness." Well, Mr. Price was smart enough to know there's no sense not going along with it, because the judge has already told me how he's going to rule, so he just kind of meekly said, "No objection." So now her videotape was probably close to 2 hours, but I'm going to get straight to the crux of the matter because I'm not about to look. I hate to say this, but it'll put you to sleep pretty fast, some segments of it. But at any rate, she indicated that at the time this thing, well, December 31st, 2008, because they apparently did prepare a financial statement just prior to collapse, but she indicated there was $7.2 billion in these Stanford CDs, okay? That's where the figure that you've heard bandied around so much, an estimated $7 billion in losses to all of the investors across the board, that's where that number's coming from, because those securities were essentially worthless. And here's what she further testified to. She said the bank collectively reported $8.3 billion in assets, but she said, notwithstanding the fact that Stanford International Bank reported $8.3 billion in assets, she said her extensive analysis indicated that all of the Stanford entities had less than $1 billion in assets. She indicated that Stanford International Bank was insolvent from 1999 forward, so that's quite a period to be insolvent. What she did is she said we took their reported assets, we backed out, and I'm going to get to the key asset right here shortly, and then we subtracted the liabilities, and that's how and it had columns showing that they were insolvent for basically 9 years. Remember, I told you, and I gave a little example in a table beneath the features showing that you reach that point in the U.S. and you're going to be shut down. In fact, they're not going to let you reach the point of being insolvent. You know, if your capital starts dropping down to critically low levels, that's it. They're going to close the doors, okay? Here's one question that, I've had a number of people ask, and I didn't have the answer until today. And that was, well, how did Alan Stanford manage to get the money out of the bank? And here's the answer. In 1999, it showed a loan from the bank. Now bear in mind, this is a bank with $8.2 billion, at least at the conclusion, total assets. But in 1999, it showed a $52 million loan to Alan Stanford personally. On December 31st of 2008, that loan value to Alan Stanford personally was $1.79 billion. She indicated that it really shouldn't be considered a loan because it most certainly was not collectible, that he had nowhere near that capability to repay that loan, and basically that what was going on is Stanford International Bank would advance him money in the form of a loan to support his lavish lifestyle, and we certainly know by all accounts he had an extremely lavish lifestyle. She said, don't think of this as a bank, as a normal bank. It's not. There were no checking accounts. They didn't make loans that any regular bank would make. They just simply did not do it. They did have some investments in what she called, when a security is so relatively illiquid or lack of a market for it, it's traded on what's called the pink sheets. She said they had some of those assets. And she stressed the fact that brokers could earn a 3% incentive a year for a CD, and that 1%, oftentimes over 1% of that would go to the financial advisor. So folk like Jason Green and others certainly had a vested interest to push these Stanford International Bank CDs. She indicated that in the year 2002, Stanford International Bank paid 4 times, let me say that again, 4 times the average rate that you could get in the United States for a comparable CD. So, in other words, if CDs were here for the same maturity, we're paying 3%. Stanford International Bank, you could get 12%. She said that in 2006, that ratio was at 1.5. So in other words, if a CD in the United States was paying 6%, the CD in Stanford would pay 9%, 1.5 times. She said there were instances of CDs that paid ranging from 11.7% to 14.9%. And she indicated that anyone ought to be able to look at those kinds of returns and wonder, how can this be possible? And that if it sounds too good to be true, it is too good to be true. So that's it. I have crammed quite a number of hours of testimony into what's looks like about 15, 16 minutes. Ms. Van Tassel's video deposition will continue in the morning. They indicated it will go on for another hour and 15 minutes. I'm going to be honest, I am going to sleep in. I will certainly be there to cover the trial tomorrow, but I'm glad they gave the advanced hint that that's going to go on for another hour and 15 minutes, because the situation is that this bank was insolvent. Her testimony is clear in that regard. There was a whole lot more material, but I've hit what I consider to be the really critical material here. And it goes back to Mr. Blunt's opening arguments. Does it sound a little too good to be true? Now Mr. Price has tried to emphasize that these were not sophisticated investors, that they may know a lot about the operations of a plant at Exxon, but next to nothing about the operations of a bank in Antigua. Now, Miss Eddy did object to that, but I can tell you what I've seen as a trend, and it goes back to my critique of Mr. Price's modus operandi of posing questions. He basically testifies and just wants the witness to go along. He'll just say, for example, pretty reckless, wouldn't you agree? Pretty reckless, is it not? So and of course those type of questions are leading, and trust me, Phelps Dunbar attorneys, particularly Miss Eddy, have done their job about objecting. The only thing I can say is that the word sustained is not really prevalent in Judge Johnson's vocabulary when it comes to the OFI objecting. I have counted, I know he did twice today sustain objections, but I only recall one other. Most times it's pretty standard, noted, overruled, or lay more foundation, or rephrase, but sustained just doesn't come out. So, and let me just say one thing in wrapping up. I think 2 segments ago, I indicated that I believe that the directed verdict should have been granted. You have to realize directed verdicts are almost never granted, okay? They just aren't. But I really do feel that the evidence just wasn't there. And when I say I was underwhelmed, I mean I was underwhelmed. I was figuring that at some point there would have been a controversy about FDIC insurance coverage on this, and that hadn't even, there's been not even the words of FDIC insurance. So no one, there's been no testimony that there was a false perception that created that these things were FDIC insured. Perhaps there was that false impression, it's just not come out at all in this trial. The other thing I'll bring out is every bank failure entails some level of fraud. And the mere fact that, now obviously this was a pure fraud Ponzi scheme, but there has been zero, Z-E-R-O, evidence that the OFI had any substantive or even suspicion of that until June the 5th, 2008, at which time they were told to stand down. We're the Department of Justice, we've got it. Mr. Seymour had testified that the SEC revealed in that meeting that they had been conducting an ongoing, and he said 4-year investigation. And Mr. Seymour had said, had we been privy to that, sure, we may have initiated action, but we were not privy to it. My statement that I would have granted the directed verdict shouldn't be taken lightly. I feel like the evidence just simply was not there. Having said that, it's going on to the jury, this whole comparative fault thing is probably going to weigh pretty heavily, and that's why they fought so much on it. So that's going to do it. I want to thank everyone for their dedication. The good news is we've got 14 jurors, so even though 2 got stricken with COVID, everything's going to go on just fine, even though Mr. Price said that he's not happy with the development, he just has to live with it. That'll be it. That'll be a wrap for today. We will give you a report of what goes on in court tomorrow, hopefully sometime after it ends, although Judge Johnson indicated expect a full day tomorrow. In terms of when this may go to the jury, he did get a commitment from the Phelps Dunbar attorneys that it would certainly be this week. Probably tomorrow I can give you a much more definitive answer. I guess there's a slight chance it may go to the jury late tomorrow. I kind of doubt it, but it might. But for those of you who want to show up as it goes to the jury, Thursday looks to be the most likely day, but it is possible it could be late tomorrow. So with that, I want to thank everyone for the dedication, and we will look forward to giving you tomorrow's synopsis of what goes on in the Stanford Victims versus OFI litigation. Thank you so much.